Welcome to the Secrets of Asset Protection. My name is Douglas Lodmell, and today we're going to talk about the case of Mr. John Target. Mr. Target called my office a few months back. He was a real estate investor, small-time developer in Florida. During the past 10 years, he'd actually done very well. Florida real estate has been up, as it was all across the country. During that time, he had a lot of investors, friends, onlookers, seeing what he was doing, and a group of them actually tried to emulate what he was doing. They had been investors in his other projects and they had made some money, and they thought it's time for them to do their own deal. So what happened is they actually offered Mr. Target a 10% interest in their deal. They wanted him in, and they called it a bonus for him doing so well in his other deals. So he accepted, and here's how they set it up. They created an LLC in Florida to hold a real estate investment project. Each of the members, these are the three people that had been part of his previous deals that were doing this deal. One of them had 25%, the other one had 40%, and the other one had 25%. That's 90%. They gave Mr. Target a 10% interest in the limited liability company. Now, he is familiar with a limited liability company. He understood that holding a membership interest of a limited liability company didn't create any risk for him, because a limited liability company does just that. It limits the liability of the members from the actions of the deal. So he didn't see any risk. He also did not participate in setting this up. These three members chose the property, put together the deal, and did everything. They contributed the initial money, and he contributed no money, had no management responsibility, was only a member. That's it. What happened? Here's what happened. The project went bad. The deal goes bad. This is around 2006, so we understand what happened in Florida real estate as it did the rest of the country. The deal went bad. Various parties related to this deal sued because a lot of money had already been put into the project and was now gone. Who did they sue? Well, who did the deal? The limited liability company. This right here, the same company. And what happened is they actually got a court judgment of $1.6 million. So here's where the interesting part comes in, and here's where I got the call. The LLC had no assets, none. The deal was bad, it went bankrupt. So there was no assets in the LLC to satisfy the $1.6 million judgment. Here's what the judgment creditors did. They went back to the court and they said, Your Honor, this LLC, it's actually the alter ego of these members. And we're going to ask you to pierce it because the way they treated it, the way the deal was set up, we don't think that you should respect the limited liability company, the nature of the LLC. And you know what the judge said? I agree. We are going to pierce it. So he actually ignored the LLC. He just ignored it. He dropped it, and then he looked through to each of the members. And he said, this judgment of $1.6 million is now attributable to you directly. Now, this is obviously a shock to Mr. Target, who saw no risk or liability for him accepting a 10% interest. However, now he's on the hook. How much is he on the hook for? Well, you would think 10%. That's not the way the law works. The way the law actually works is when the corporate veil is pierced, these members are held joint and severally liable. Now, what that means from a legal standpoint is that they are all liable for 100% of the $1.6 million. Did you get that? They're all liable for 100% of the full judgment. So here's where the really tricky part comes in. These members individually don't have any money. This deal was their big shot. They weren't sophisticated investors. They tried, they got in at the wrong time. Guess who is the only one that has any money on the table? That's right, Mr. Target. So now Mr. Target, who had what he thought was a risk-free ride-along interest, is now being held responsible for $1.6 million judgment on a deal which he didn't structure, didn't manage, didn't contribute anything to. The case is now in appeal. That's when my office gets the call. So what I want to do is clearly look at the lessons that we can learn from this. First of all, limited liability company, it's a great tool. We use it a lot. I use it a lot in my planning. However, if it's the end of the line, if it's your only asset protection, theoretically it should have worked here. No assets, the case would be over. It doesn't always work. That's the problem with any kind of domestic entity. Why doesn't it work? Because there's a U.S. judge who is an individual person who has the power to ignore it, to just look right through it. And that's what happened here. So let's take a look what would happen, because right now he's pretty much on the hook. He's got to now fight the underlying case, fight an appeal, and to throw salt on the wound, they're asking this group to post a bond in the full amount of the judgment, $1.6 million, just to take it to appeal. So again, who are they looking for to post that bond? Mr. Target. So now, bad situation in what should have been a clean deal. Let's look at how I would have structured this deal had we had this before it started, and we'll look at what would have happened if we had had asset protection in place.